Hello, I'm Glenda Clausell, an attorney in Houston, Texas at the Clausell Law Firm. My practice area includes estate planning and probate.
And hi, my name is Mac Pierre-Louis, an attorney here in Houston, Texas, managing attorney at Pierre-Louis and Associates PLLC, where I focus mainly on civil and family law. Today, we're talking about the intersection of family law and probate, and we got a wonderful topic for you. But first, a disclaimer. As usual in all these videos and on this YouTube channel, remember, all information in this video is for educational purposes only and for informational purposes only and should not be deemed legal advice, nor does the information create an attorney-client relationship. So if you have questions about specific facts in your case, please consult an attorney so that they can better advise you. All right, with that, Glenda, good to see you again.
Good to be here, Mac.
All right, so today we're discussing something that a lot of people have questions about, and that's transfer on death deeds. And wanted to just discuss what they are, how they work, why they're important, why they exist, and wanted to have kind of our in-house probate guru, Glenda, to discuss this. So Glenda, what's a transfer on death deed?
A transfer on death deed is an instrument used to transfer real property to another person while you're alive. It works along the lines of an insurance policy and a payable on death bank account. So it doesn't take effect until the death of the person transferring the real property.
Okay, so when would a person typically use a transfer on death deed?
When they wanted to, for instance, if they want to avoid having this asset being transferred through the probate process, or if they wanted to make sure that the person that they are interested in owning the property has the property upon their death without doing anything extra, they would use a transfer on death deed.
So what are some benefits do you see in why a person might want to use a transfer on death deed instead of just going through the regular old will process?
Hassle. When you have some property and you want to move it out of your estate, you can do a transfer on death deed, and upon your death, the property, similarly to insurance and a bank account, goes to that particular beneficiary. So it's no longer part of your estate, hence it would not be included in your will, the assets that are listed in your will. It could also be utilized for peace of mind if there is some sort of bickering between the relatives or anyone. You can make sure that you do a transfer on death deed, and upon your death, it transfers to that particular person, and you've avoided all of the drama.
Okay, so to make sure I understand, when you use a transfer on death deed, you're basically transferring the home, the homestead, the property, at the time of your death, not before. So what can you do with the property while you still possess it?
Right. A transfer on death deed is not only utilized for the homestead. It can be utilized for other property that is not the homestead. So what you would do is you would transfer the property, you'd file the deed in the real property records, and then you would go about your merry way. Now, filing the transfer on death deed does not restrict your ownership rights. You can sell the property, you can split it in half, you can even cancel the transfer on death deed. So again, by completing the transfer on death deed, you as the owner, you still have 100% rights to do what you choose to do with your property. And you can also cancel the current transfer on death deed, and you can put another one in for someone else. Again, you retain all of your rights to your property.
Okay, so if you retain your rights to your property and you sold the property before you die, what's the effect of that on the transfer on death deed?
That is an effective cancellation of the transfer on death deed, because the property no longer is you no longer own that property. And remember, you can only give away that which you own. And so if you sell the property that is listed in the transfer on death deed, that property no longer is yours. So the person who had the expectancy of owning that property or that land or what have you, they just don't, plain and simple.
Okay.
Again, your rights are not restricted.
Okay, and have transfer on death deeds been around for a long time? Because I believe, that this is kind of a new thing, right?
Right. It's an offshoot of an enhanced life estate, commonly known as the Ladybird deed. So the transfer and death deed, which is different from the enhanced life estate or Ladybird deed, became in effect in 2015. So it's a relatively new instrument for those wishing to transfer property to utilize.
Okay, and is it specifically a Texas thing, or are there other states that use it as well?
Other states have something similar to a transfer on death deed. The titling may be different, but the effect is very similar. It is not universal. In a guesstimate that I'm going to say there are probably less than 20 states that have them currently. Each state's rules, laws are different, but Texas is one of the latest to come on board with this idea of a transfer on death deed.
Okay, and it came out in 2015?
2015, it became the law.
Okay, so let's talk about the intersection of family law and transfer and death deed. I do a lot of civil and family law work, and let's say a spouse is going through a divorce, but let's say they had, the transfer and death deed that was in effect before the divorce. What exactly happens when the divorce occurs?
If the spouse transferred property to the other spouse and there is a divorce, the divorce acts as a cancellation of that transfer to the other spouse. Similarly, in a will, if there was a divorce, anything given to that spouse during the divorce is null and void.
Okay. Well, if folks have questions, they can definitely reach out to us, and specifically to you when it comes to transfer on death deeds. So you want to give your information out so that people can know how to reach you?
Sure. Glenda Clausell, that's my name. The phone number for Clausell Law Firm is 713-228-2255. The email address is gclausell@clausellawfirm.com.
Okay, and your website, spell it out because we just want to make sure that folks will be able to see it.
The website is clausellawfirm.com, CLAUSELLAWFIRM.com.
Okay, and again, I'm Mac Pierre Louis, attorney at law. I can be reached at macpierrelouis.com, MacPierrelouis.com. Also, the owner of YourChildSupportLawyer.com, where this video will be featured. All right, well, until next time, Glenda, is there anything else you want to say to close us out?
Well, I think it's important for everyone to take an inventory of who they are and what they have, what their assets are. And if there are people in their lives that they care about, I would suggest a simple estate plan, including a will and some powers of attorney.
All right, well, until next time, thanks so much.
Thanks, guys.